Hello and welcome to The View from Mayer Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayer Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome back to the Mayer Brown Employment Law Christmas Podcast. And we've reached the halfway point, fourth case for each of us. I'm delighted to be joined again by Miriam Bruce.
Hi everybody.
And Miriam is going to, she's going to develop a bit of a theme, I think, over her next three cases. So what are we going to start with, Miriam?
So the second half of my choices are going to be all about whistleblowing, which I think has been a real hot topic in 2017. And the first case I'm going to cover is Chesterton Global and Noor Mohammed, a Court of Appeal decision. So I think the law relating to whistleblowing is one of the most complicated areas in employment law at the moment. Part of this is because of the high stakes that come with a whistleblowing claim. However, additionally, the law in this area is continuing to develop, and sometimes in some quite surprising directions, as we'll see over my next three choices. So by way of reminder, in order to be protected against detriment or dismissal under the whistleblowing legislation, a worker must have made a qualifying disclosure. That is, any disclosure of information which, in the reasonable belief of the worker making it, is made in the public interest. Now, the words "in the public interest" were added for disclosures made on or after the 25th of June 2013 in order to reverse case law, which had held that the definition of a qualifying disclosure was broad enough to cover a disclosure about a breach of the whistleblower's own contract of employment, even though there was no apparent public interest in that disclosure. So looking at the facts of Chesterton, this case looked at when a disclosure would be in the public interest, and I think, interestingly, in the context of someone who's complaining about their own contract of employment. So Mr. Noor Mohammed had complained that Chestertons were manipulating their accounts so as to reduce bonuses payable to him, a number of his senior manager colleagues, around 100 people in total. Chestertons argued that the public interest test was not satisfied just because other employees were in the same position as Mr. Noor Mohammed. This was still essentially a private complaint about his own employment contract that just happened to affect others as well. In order to satisfy the public interest test, Chestertons argued the issue had to extend outside the workplace. Now, the Court of Appeal disagreed with that view. They said that the fact that a disclosure relates to other employees is not normally enough on its own to meet the public interest test, but a disclosure does not necessarily have to extend outside the workplace. Instead, there are a number of factors to be considered by an employer. These were the number of people affected, although sheer numbers alone will not normally be enough. Secondly, the type of interest concerned. Is it important or trivial? Thirdly, the nature of the wrongdoing. Was it deliberate or inadvertent? And finally, the identity of the employer was relevant. How prominent an organisation was it? So in this case, the Court of Appeal said it wasn't just that 100 employees were affected. The alleged manipulation of the accounts was serious and significant, apparently between 2 and 3 million of allegedly misstated liabilities, and deliberate. As a well-known national estate agent, Chesterton was a prominent organisation, and so disclosure of their alleged deliberate wrongdoing could plainly be regarded as being in the public interest, even though, importantly, that was not the claimant's motivation here in raising his complaint. Of course, his own motivation was the fact that he was impacted in relation to his bonus. So what do I think this case means? In my view, the ability of an employee to attract whistleblower status by complaining about a breach of their own employment contract lives on. Whether the test is passed will depend on the circumstances of the particular case, taking into account the factors referred to above and by the Court of Appeal, and no doubt others, as case law continues to develop in this area. The test hasn't, in my view, become any simpler, and it will remain an issue for employers to consider every time there's a whistleblowing complaint, at least where the wrongdoing relates to the employee's own contract of employment.
I tell you what struck me when this case came out and we talked about it in the group and the training sessions and so on, is I find it very frustrating because it doesn't really help.
I think it makes it harder.
It seems to me that what you ought to be aspiring to here is something that allows people to know, if I do this, I am a whistleblower, I am protected. Or, for an employer's perspective, I can't do this because they're a whistleblower. But here you have something, and classically, the way we see these things, there will be a tie-in between the employee's own position and the alleged whistleblowing. Not always by any means, but that's not unusual. And so disentangling that personal motivation, or that personal impact, I should say, from is it or isn't it whistleblowing, with colossal consequences both ways. I think the legislation may not be terribly well drafted, but it is a frustrating outcome.
I think so. I think
there is no shining light.
No, it makes it very difficult for anybody really to know if someone is genuinely going to be protected or not, and the ability to retrospectively
come up with the
reason, I think, is pretty tough on employers.
Okay, well, thank you very much indeed. As I say, I think we're going to be returning to the theme of whistleblowing again.
It's a Christmas treat.
It's a Christmas treat, yes. So thanks very much for listening, and we'll be back again tomorrow with the next of our Christmas employment law podcasts. Take care, everyone.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayor Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayor Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome to the Mayor Brown Christmas Employment Law podcast series. And it's my choice today, so we get to open another door on our notional advent calendar and see what's behind the door. And I've got a pair of cases. I suggested in an earlier podcast that Miriam was cheating by including a pair of cases. Well, I'm going to take a leaf out of her book and cheat too, because we're dealing with two cases, and they are the Uber case and the Deliveroo case. I thought because they are so closely aligned, it made sense to treat them as one choice. At least that's my rationale, and I'm sticking to it. Let's start with the Uber case. The basic case, of course, a number of Uber drivers bring claims. In order to succeed in those claims, the drivers need to establish they are correctly classified as workers. And this goes to the Employment Tribunal as a preliminary issue. A worker is the halfway house category between an employee, someone who works under contract of service, and being someone who is self-employed or in business on their own account. For there to be a worker relationship, there needs to be a contract under which the individual performs work personally for another party to the contract, and where the individual is not carrying out a professional business on their own behalf. In other words, there needs to be a contract, there needs to be personal service, and when you look at the relationship between the alleged worker and the alleged employer is not the employer but is a customer or client of a business undertaking run by the individual. It was accepted by the tribunal that drivers had complete freedom to choose whether or not they wished to work for Uber. However, if they were interested in receiving work from Uber, they needed to log into their Uber app and then be available to take passengers. The whole process is closely controlled by Uber. Uber allocates passengers to drivers through the app. Uber puts the driver and the passenger into contact. The driver is not told where he or she is going until the passenger has been picked up. The app offers route guidance to the driver, but it's up to the passenger what route to take. The driver cannot charge more than the Uber recommended fare, and the fare goes directly to Uber via the app and then Uber account to the driver less a service charge. At the Employment Tribunal stage, it was accepted that the drivers were providing a personal service. This was not one of those worker stater cases where the individuals concerned could provide a substitute in reality or in theory. Here, drivers were accepted personally by Uber and so were providing a personal service. The right, for example, to use the app was a personal right, could not be transferred to anyone else. The claimant's case was that Uber, and in particular Uber London, were able to control the drivers sufficiently to enable them to be treated as workers working for Uber London. The passengers were not the customers of the driver, but customers of Uber, according to the claim. Well, the Employment Tribunal honed in on the AutoCleanse case, where, if you remember, the Supreme Court had decided that if contract terms did not reflect the true agreement between the parties, then the court could identify what it said was the true agreement. It was, quote-unquote, unreal, according to the tribunal, to deny that Uber was in the business of supplying transportation services. Simple common sense led to that conclusion, according to the tribunal. Having decided that the individuals were workers, the tribunal then had to look at how to measure the working time for the purposes of establishing whether or not individuals had been deprived of the national minimum wage, the right to appropriate rest breaks, holidays, etc. The tribunal decided that both for the purposes of working time and under the national minimum wage, individuals were working when they were in the area where they were authorised to drive, they turned on the app and indicated they were willing to work. This crucially means that time spent waiting on duty for bookings will count as working time for the purpose of the national minimum wage and working time regs themselves. Uber, unsurprisingly, appeals to the AT. The AT dismissed Uber's appeal completely. The AT felt the key question was that when the drivers are working, who are they working for? So they start off with the question when, start off with the question who are they working for and defer the question of when are they working. The difficulty for Uber fundamentally was the Employment Tribunal had found as a fact that the documentation drawn up by Uber was not in line with the true position. Try as Uber might, it could not get past that finding. And once that finding was upheld, it was always going to be much more difficult for Uber to challenge the Employment Tribunal's decision. And the EAT said the degree of control and integration into Uber's business justified the findings that individuals were workers rather than self-employed. Let's compare that with Independent Workers' Union of Great Britain and Roo Foods Limited. Here, we got to a very different outcome. Factually, drivers apply to Deliveroo, they're given an interview and undergo criminal checks, they have a trial shift, check their suitability, they get food hygiene and safety training, they get given personal access to a smartphone app which allows them to show whether they are available or unavailable to take on work. Jobs can be taken on by riders but then subsequently rejected. There's no penalty for turning down work. The documentation under which riders work is very clear. They are independently self-employed, according to the documentation, and they have to pay their own tax and national insurance. There's no obligation on them to undertake any work. It's made clear they are entitled to work for competitors. There's no requirement to wear Deliveroo uniform or kit. Indeed, it became clear that they were entitled to wear competitors' uniforms while working for Deliveroo. There would be no sanctions. The rider documentation also said they could provide a substitute rider at any point for any reason. The fact of substitution did not even need to be passed on to Deliveroo. There are only a couple of categories of individuals who were not permitted to act as substitutes. The obvious ones, individuals who had previously been dismissed by Deliveroo for material breach of their obligations, for example. The rider was made responsible for what the substitute did. The rider was the person paid by Deliveroo, and the terms of any subcontracted deal between the rider and substitute were a matter for the rider and the substitute. It was not a matter for Deliveroo. Deliveroo's case hinged on the substitution clause. If you remember, in the Uber case, the tribunal found the documents did not reflect the realities of the situation, and it could look behind the documents. Here, the CAC, which was the body determining the case, identified the fact that it's very odd that Deliveroo would go through a rigorous, a strict screening and training process for riders, but then permit riders to substitute other riders for them to undertake work. Subcontracting could go to people who'd never been trained or screened. The union's case, on behalf of the riders, was that this showed the substitution clause was a sham. Deliveroo, however, was able to give evidence that the substitution clause was used in practice. So, on that basis, there was a clear right of substitution and clear evidence that it was used in practice. albeit by a minority of riders. So the CAC accepted there was no duty of personal service, and at that point, go back to what I said about the test for workers, the workers were self-employed, they were not workers. So at the moment, the message seems to be that an unfettered right of substitution, if exercised in practice and properly documented, seems to be a much better way of defending worker status cases than arguing that the individual is in business on their own account. But it probably comes at the cost of maybe some reputational risk for a gig economy employer, where customers might be surprised to learn that the person delivering their food late at night perhaps is not really connected with Deliveroo. So those are the pair cases, the Uber and Deliveroo cases.
I think it's an interesting contrast, isn't there, with Deliveroo and Pimlico Plumbers, which is the other status case, which didn't have an express substitution clause in their contract, even though it happened in practice, and that was held against them. So I think that's going to the Supreme Court.
Yes, that's the Supreme Court, and I suspect we'll come back and we'll be talking about that in our New Year's Resolutions podcast series, which will come on to at the end of this series. But yes, I think that's
and
a
we should
point.
say Uber's being appealed as well, we understand.
Yes. Again, entirely unsurprisingly. So, thank you very much indeed for listening. That's all for this podcast episode, and we'll be back with Miriam's penultimate choice.
Quite.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayor Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayor Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome back to the Mayor Brown Employment Law Christmas Podcast. I'm joined, of course, by Miriam Bruce.
Hello everyone.
And we're on to your penultimate case.
Yep, and it's another case about whistleblowing.
Do I need to worry about this? Okay, over to you.
So the second case, whistleblowing case I've picked, is the Court of Appeal decision in Royal Mail and Jutty, which considered whether an individual had been automatically unfairly dismissed, where the dismissing officer did not have the claimant's protected disclosures in mind when dismissing her. So let's start with the facts. The claimant was recruited to work for Royal Mail. Her immediate line manager, an individual called Mr. Widmer, and the facts here are complicated, so I can only give a brief summary, but in essence, she reported some potentially regulatory breaches to Mr. Widmer, but in the face of a hostile response from him, withdrew the allegations and accepted she was mistaken. Her relationship with Mr. Widmer then deteriorated, and she ended up being signed off with stress. Some months later, a manager was appointed who had no previous involvement with the claimant to consider whether to terminate her employment on the grounds of her unsatisfactory performance. Although reference was made in the disciplinary process to the claimant's whistleblowing allegations, Mr. Widmer did not disclose to the disciplining manager what had happened, and so the disciplining manager, genuinely and reasonably in ignorance of the whistleblowing allegations, dismissed the claimant. The primary issue by the time the case gets to the Court of Appeal is whether the disciplining manager's innocence of any wrongdoing absolved the company of liability for the fact that a decision to dismiss had been taken on the basis of Mr. Widmer's actions, which were found to be motivated by the protected disclosures which the claimant had made. It was also found that Mr. Widmer's actions made it inevitable that the claimant would be dismissed. So the claimant eventually brought claims that she'd been subjected to an unlawful detriment contrary to section 47B of the Employment Rights Act, and that her dismissal was automatically unfair contrary to section 103A, i.e. because she was dismissed for whistleblowing. And in today's podcast, I'm just going to focus on the dismissal claim under section 103A. So looking at 103A in a bit more detail, this provision says that an employee is treated as being unfairly dismissed if the reason, or if more than one, the principal reason for dismissal is that the employee made the protected disclosure. So here, was the employer treated as having dismissed the employee because of the actions of the dismissing manager alone, based on what she knew, or was the employer deemed to have dismissed based also on Mr. Widmer's knowledge? At this point, the Court of Appeal came to a clear decision, and it's one which is helpful to the employer. They looked at the test in ordinary unfair dismissal cases. What sort of knowledge is attributed to the employer? Remember that here, the dismissing manager both genuinely and reasonably believed that the claimant should be dismissed for poor performance. She was, however, misled by Mr. Widmer as to the true position with regard to the protected disclosures. The Court of Appeal accepted that when identifying what the reason for dismissal was under the ordinary unfair dismissal test, the tribunal looked only at the mental processes of the person or persons who were authorised to, and did, take the decision to dismiss. Although the claimant tried to argue that a wider test should be applied here when it came to protecting whistleblowers, the Court of Appeal did not accept that. The court helpfully went on to give some guidance about the circumstances in which a malicious agent, who is not the person taking the decision to dismiss, could be treated as acting on behalf of the employer. For example, if you had a malicious colleague who had no relevant managerial responsibility for the disciplinary process, but who presented false evidence to the process, then that knowledge is not attributed to the employer. The employer under Section 103 has not acted unlawfully. Secondly, if the malicious colleague is the victim's line manager but does not have responsibility for dismissal, then again this knowledge is not attributed to the employer, and that's what happened in this case. The Court of Appeal considered there would be a strong case for treating the employer as covered by the knowledge if the malicious colleague is conducting part of the investigation process, even if they're not actually part of the dismissal itself. Nonetheless, that point was left open for another day. They also left open the situation where someone at the top of the tree, say the CEO, procured someone else's dismissal, even if they weren't the disciplining manager themselves. Here they said again that the CEO's knowledge might be capable of being attributed to the employer. On that basis, the Court of Appeal were clear that the employee's claim under Section 103 failed. The disciplining manager had acted genuinely and reasonably, but in ignorance of the malicious colleague's actions. Unfair dismissal required unfairness on the part of the employer. Having said that, employers dealing with disciplinary hearings where there are whistleblowing allegations may need to proceed carefully in light of this decision, in my view. It may make sense in some cases to isolate the decision maker so that the decision is taken genuinely and reasonably in ignorance of the whistleblowing allegations. However, where there's a linkage between the allegations, it may make sense to ensure that the disciplinary manager knows about the allegations so that they can be taken into account and fully investigated. I did mention at the start that this case also included a separate claim for dismissal-related detriment against Mr. Widmer under Section 47B. The Court of Appeal didn't come to a conclusion whether such a claim is possible. Fortunately, another case, Osipov and International Petroleum, did, and we'll look at that case later in our 12 Days of Christmas rundown.
So my take on this case was that it was a really sensible decision in that if you are a decision maker, you should not have your decision tarred with deemed knowledge of something you genuinely reasonably knew nothing about. And so I get that entirely. I think it leaves open the issue about whether or not the employee who's lost out can bring effectively a claim that makes the employer liable just by the route of going against the alleged malicious witness or whatever it is. So to that extent, there's still everything to play for. But I thought this was a sensible decision because it's not right that decision makers are found deemed to be guilty of quite a serious fault, which is just not the case.
Yeah, it's good to have a helpful decision in our rundown.
Shock horror. Law helps employers occasionally. So thank you very much indeed for listening to our podcast series. That's the penultimate case from Miriam. I've got 2 more to go, and we'll be hearing the first of those 2 cases tomorrow. And we hope you tune in to listen to that tomorrow and work out what it is. If you need any incentive, it's a brand new case. It has not featured on the podcast series. This is the point where I have a Radio 1 DJ, I'd be saying there, straight in with a bullet at number 2, or words to that effect. Anyway, take care, and we'll talk again tomorrow. Bye.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayor Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayor Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome back. It's my penultimate case in the Mayor Brown Employment Law Christmas podcast series. I'm joined by Miriam Bruce.
Hi everybody.
I haven't scared her off yet. And we are talking today about a brand new case. And that's one of the joys of employment law. And I mean this genuinely actually. It moves so fast that when we started off this list, the following case didn't feature on it at all. And it was decided yesterday. And we looked at it and we thought, no, this is sufficiently significant that it needs to go into the top 12 list, and I bagged it as my own. So, penultimate case today, King and the Sash Window Workshop Limited. This case is obviously hot off the press, so we are giving very much our own personal take on this case, but equally I'm going to go through this case in a little bit more detail, partly because it's not been on the podcast series before, so it's the first time we've dealt with it. The claim concerns an alleged underpayment of statutory holiday pay. Mr. King worked for Sash, ostensibly as a self-employed commission-only contractor. He did so for 13 years, before retiring in October 2012. He was never paid any holiday pay on the grounds that Sash considered he was self-employed. After he retired, he sought to claim all 13 years of holiday pay. This was rejected by Sash, and so he brought a claim in the Employment Tribunal, claiming 3 different types of holiday pay. First of all, he claimed he was entitled to holiday which had accrued but had not been taken in his final year of work. Secondly, he claimed he was entitled to holiday pay for holiday he had actually taken between 1999 and 2012, where this had not been paid. Thirdly, in the so-called Holiday Pay 3 category, he claimed he was entitled to holiday pay in lieu of accrued but untaken holiday leave throughout the whole period of his relationship, i.e. holiday for which he'd never claimed and which he'd never not actually taken, where he had not been paid at all. This holiday pay, this category 3 claim, goes all the way back to 1999. Before going any further, it's important to remember that in the UK, when the holiday pay claims started appearing, the government passed the Deductions from Wages Regulations 2014, which meant there was in effect a 2-year backstop on holiday pay claims. That's a slight simplification, but that's the gist of it. In addition, the courts have decided that if there's a gap of more than 3 months in relation to a failure to pay holiday, this broke the chain under the wages deduction for wages provisions, and so employees were not able to claim under the working time regulations for the period prior to that gap. In other words, if there's a 3-month period in which employees were not taking European statutory holiday leave, this would break the chain, and prior holiday was not then recoverable under the regulations. And this comes out of the so-called Bear Scotland case. By the time the case had got to the European Court, it was accepted that Mr. King was not self-employed, he was in fact a worker. Workers have rights to statutory holiday pay under the Working Time Directive. Article 7 provides that member states are to take the necessary measures to ensure that every worker is entitled to at least 4 weeks annual leave. This may not be replaced by a payment in lieu, except where the relationship is terminated. The Working Time Regulations 1998 provide for the equivalent right under English law and provide expressly that holiday may only be taken in the leave year in question and may not be replaced by payment in lieu, except where the relationship is terminated. Well, by the time the ECJ is considering matters, it's accepted Mr. King was entitled to holiday pay, accrued but untaken in the final leave year, Category 1. Secondly, he was also entitled to holiday pay for periods of holiday which he had taken between 1999 and 2012, but in respect to which no payment had been made, Category 2. That left, as the sole point for debate, whether he could claim payment in lieu for accrued but untaken holiday leave throughout the whole period of 13 years during which he was a worker, less the holiday pay which he'd now been paid. So, Sash claimed that Mr. King was not entitled to carry over periods of untaken annual leave into a new holiday year. Since he had not brought a claim in time following the ending of that year, he'd lost his holiday entitlement for that year. This right could not be restored to him when he ceased to be a worker, according to Sash, because he'd already lost his entitlement to that claim. Mr. King, however, claimed that his holiday pay was carried over indefinitely until the end of the worker relationship. Well, first, the ECJ accepted that a worker could claim for holiday pay which had not been paid to him, even if he had made no attempt to actually take the holiday in question. The court's logic was that the purpose of holiday pay was to enable the worker to have rest. If holiday pay was disputed, the worker's rest would be impacted. Indeed, the uncertainty as to whether or not the holiday would be paid for would dissuade a worker from taking holiday in the first place. Let's face it, it's pretty hard to argue with that bit. Therefore, Mr. King's claim was not affected by the fact that he had failed to take or seek to take holiday over a 13-year period. The court then moved on to the question as to whether or not the national provisions, which meant that a worker lost holiday that was untaken at the end of the year, were incompatible with Article 7 of the directive. In other words, the UK provisions, to the extent that they meant that Mr. King lost his rights to claim holiday pay in, say, 1999, by not suing, could he effectively deprived of his 1999 holiday pay at some point after 1999 by the just passage of time. The court pointed out the holiday and pay entitlement was given to the worker unconditionally under the directive. It's an unconditional right. Member states could not exclude that right or provide for it to only be subject to certain conditions. It followed from this that a worker who was unable to exercise his right to take holiday and receive holiday for reasons beyond the worker's control was entitled to a full payment in lieu on termination of the relationship. Now, the payment, according to the European Court, had to be calculated so the worker was put in a position comparable to that which the worker would have been in had the worker exercised the right during the worker relationship. Well, those of you with reasonable memories will recollect that a similar issue has already arisen in relation to sick pay and periods of sickness absence and holiday pay. In the case where a worker had been off for a long period of illness, the European Court had accepted it was possible to have a limitation on the carryover period. They had said that Article 7 did not preclude a national provision limiting the carryover of holiday pay so that it had to be taken within 15 months after the end of the holiday period in question. Put another way, if you were unable, because of sickness, to take holiday, you had up to an extra 15 months to take that holiday. But crucially, after that it was lost. So here, if Mr. King had been sick for the whole of 2000, and assuming the holiday pay year was the calendar year, then by April 2012 he could have been deprived of that holiday pay. But here, the European Court distinguishes between specific circumstances where a worker is unfit for work for several consecutive holiday years, and this situation, where Mr. King worked throughout those holiday years. The court said it was for the protection of employers that a 15-month period was permitted in circumstances where they'd had to accommodate an employee or worker who was off sick for a prolonged period. In those circumstances, the holiday pay no longer reflected the actual purpose of the right to paid annual leave, because the individual had been off sick. Here, however, Mr. King had worked through the period. The employer had the benefit of his services through that period. It was irrelevant that Sash Windows believed that Mr. King was not entitled to accrued holiday pay at that time. So the sick pay exclusion was not a proper analogy, according to the European Court. Also, the ECJ pointed out that if the worker's accrued entitlement to paid annual leave could be extinguished, this would amount to validating conduct by which an employer would be unjustly enriched to the detriment of the very purpose of the directive, which is there should be due regard for workers' health. All in all, this is a crushing decision for companies who have workers as part of their operation, but where that worker status is not accepted by the company. This case allows individuals to go back and claim holiday pay back to the coming into force of the working time regs in the UK, i.e. 20 years ago. The fact that the leave in question is so-called Euro leave, i.e. 20 days of statutory leave, rather than the enhanced 28 days UK minimum statutory leave, well, that's going to be scant comfort for many companies. It means there is a maximum liability of 80 weeks pay due for long-serving workers, where they've not had any holiday. And this case also strips away a number of the obstacles which companies have used to try and deter claimants. However, in light of this case, I think we're definitely going to see a host of cases coming forward where companies are faced with historic and potentially painful claims for holiday pay from individuals who've notionally been classified as self-employed. It doesn't take an awful lot to see that gig economy companies must be checking their calculations right now, as this case could prove very expensive for them. So, that's the Sash Window and King case.
It's a big case, I think, a big decision, and it'll be interesting to see how companies react to it.
Yes, I imagine, because if it's also a liability that doesn't go away and gets crystallised where individuals leave, it's not even as if companies can console themselves with, well, no one's raised a claim, or we've paid off 10% of the claimants who come forward, because it's until the relationship ends. Sounds like time doesn't run.
No.
So it's a major impact. So thank you very much for listening, as always. And tomorrow we're on to Miriam's last case, and we'll look forward to hearing from that. I think we've had a trailer that it's about whistleblowing. It
is about whistleblowing.
Good stuff. All right, well then, thanks very much for listening. Take care, and talk to you again tomorrow.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayor Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayor Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome to the penultimate in this Christmas Employment Law podcast series. Miriam and I have been choosing our top 12 cases, 6 each, for cases decided during 2012. We've come to Miriam's last case. We know it's about whistleblowing, but we'll find out in a second from her exactly what it covers. But I did want to say we've really enjoyed doing this series. It's been good fun, hasn't it?
It's been fun, yeah.
And we'll be back again in the new year with the equally obviously entitled New Year's Resolutions, looking at cases that are scheduled for decision, indeed maybe a few that haven't yet started, where we think there will be claims arising. But we will be bringing that to you in January, so keep an eye open for that. And in the meantime, Miriam, what have you got as your top case for 2017?
Okay, my third and final case is a whistleblowing one. No surprises there. But I think it's the most significant decision this year from the cases that I looked at. And that's the case of Osipov and International Petroleum, which is an EAT decision. So this case focused on Section 103A, the right not to be dismissed for having blown the whistle, and Section 47B. And that latter section is the basic right that the worker has not to be subject to any detriment by any act or any deliberate failure to act by the employer done on the ground that the worker has made a protected disclosure. This expressly covers actions by other workers in the course of employment. If a worker in the course of employment subjects a whistleblower to a detriment, that is deemed to be an act of the worker's employer, unless the employer took all reasonable steps to prevent it happening. So there are two key points to appreciate up front before we get on to the facts of the case. First, the test for liability under Section 47B is not the same as the test under Section 103A, and the distinction is an important one. Under Section 103A, the employer can only be liable if the reason, or principal reason for dismissal, is the employee's whistleblowing. However, under Section 47B, the desire to retaliate against the whistleblower only needs to be a material part of the decision. It does not need to be the principal reason. Therefore, it's easier to show a detriment claim under Section 47B than it is to show a dismissal claim under Section 103A. However, there's a further complication. Section 47B claims are not available if the worker is an employee and the relevant detriment amounts to a dismissal. In other words, at first blush, if you can dismiss an employee, that claim has to be brought as a Section 103A claim and can't be brought as a Section 47B claim. The case of Osipov, however, raises the very real possibility that a claimant can claim damages flowing from dismissal against an individual who has subjected them to a dismissal-related detriment under Section 47B. So in this case, Mr. Osipov was found by the tribunal to have been dismissed by his employer, IPL, for having made a series of protected disclosures. He was awarded compensation in the region of £1.7 million, and importantly, the sum was awarded not only against his employer, but also against two non-executive directors who were responsible for the decision to dismiss and its implementation. The non-executives appealed on the basis that any compensation for dismissal-related detriment could only be pursued against the employer and not against them as individuals. However, in a significant decision, the EAT roundly rejected that argument and found that claims against individuals could include losses flowing from dismissal where the claimant has been subjected to a relevant detriment by those individuals in question. So if you put this decision together with a suggestion that it's easier to claim damages for detrimental treatment than it is to claim for dismissal, with the argument that the detriment can cover losses caused by the subsequent dismissal, then you're extending whistleblowing law quite significantly in my view. Given this decision, it seems inevitable that many more whistleblowing claims will now include claims under Section 47B to the effect that there's been a detriment caused to the employee. Secondly, the claims will also add in individuals who it's said were guilty of wrongful actions towards the claimant. This will be done partly to make the employer's life difficult, and partly because individuals will see the possibility of getting or proving damages claims against managers or colleagues under Section 47B as being an easier route to success. Of course, it remains to be seen whether the Court of Appeal, assuming that the appeal in Osipov continues, agree with the idea that whistleblowing damages for dismissal can be awarded against individuals. But for my mind, this was one of the most significant outcomes of the year.
No, I'm not surprised. I agree entirely. I think it's potentially very significant and potentially every bit as worrying in a very different way to the King case, because what you have is the ability for individuals to, if the individuals can bring dismissal-related detriment claims against managers who take decisions, and the company is then on the hook for those managers' actions, that seems to be a significant loosening of the law, but it's also going to be much more complicated for employers defending these claims because, as you said, they're going to join in the managers because they're a softer target. And we all know how complicated that can make life. So I think it'd be really interesting to see what the Court of Appeal do about this, and whether they adopt the same approach, or whether they step back and go, well, this can't be the right overall outcome. So where does it break down?
Where's the line drawn? I think for the time being, it means that whistleblowing is going to become much more like discrimination in terms of going for named respondents.
Yes. Although I suppose the difference is with named respondents and discrimination, it's not an easier legal test to find liability against. So it's positive incentive. Okay, well, thank you very much indeed for your 6 cases, Miriam. Tomorrow we'll deal with the final case of the podcast series, which is the one I chose. Thank you everyone for listening, and see you tomorrow for the final episode in this Christmas podcast series. Thanks very much. Bye.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayor Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayor Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome to the Mayor Brown Employment Law Christmas Podcast series. Today we come to the final of our 12 cases. We're going to open the double jointed window behind which has got the biggest picture of all and find out which case we've got. Or maybe it's the biggest chocolate of all. Your advent calendar have chocolate or pictures, Miriam?
Chocolate all the time.
Chocolate all the time. There we go. All right. So the extra chocolate. What's the number one case? Well, sadly, I think this year the number one case is so blindingly obvious that if we'd done a poll of our listeners before we started, they'd said, of course it's going to be this case. So anyway, we are of course talking about the Unison and Lord Chancellor case. And there is, I think, it's unarguable, this is the most significant case. It's the most significant case for many years' employment, because I really do think it changes the landscape in ever so many ways. The fees regime for employment tribunals on the AT came into force July 2013, and it almost immediately ran into legal challenges, and entirely unsurprisingly. Basic idea was that tribunal claims would be divided into two, Type A and Type B claims. To take a case through for a Type A claim costs £390, for a B claim £1,200. There were limited opportunities for remission of fees, but there was obviously a very significant drop in the number of employment tribunal cases from that point on. Unison brought a case which they lost in every court before the Supreme Court level, arguing that the effect of the fees order was to deny access to justice, and they argued this was unlawful both as a matter of English common law and as a matter of EU law and the Convention on Human Rights. It was also argued by them that treating Type B claimants, which are predominantly discrimination claims, more heavily and requiring significantly higher fees from them was indirectly discriminatory. Well, the Supreme Court, relying on common law, was very, very clear that access to justice is a fundamentally important right going all the way back to the Magna Carta. In light of the fact that this is an idea deeply embedded in constitutional law, the government's impact assessment fell short of the necessary standards. Access to court was not solely of benefit to the particular individuals involved, said the Supreme Court. Cases establish legal principles of general importance and benefit to society. They become part of the common law. Having a fair judicial system to determine disputes encourages adherence to employment rights. It encourages respect for the law. In light of this, there was a real risk, according to the court, looking at the statistics and costs involved, the parties would effectively be prevented from having access to justice by the fees order. It would be futile, it would be irrational to bring a claim in circumstances where the value of the claim was not sufficiently high in comparison with the fees. On that basis, the fees order was unlawful. In any event, the principle underlying the fees order was flawed. Whilst there was no objection in principle to the idea of the users of a system paying for its cost, the fees had clearly not been set at the optimal price given the amount of cases they had driven out of the system. Lower fees, which would have had a lesser deterrent effect, could have been equally effective in transferring the cost burden to users. Well, the Supreme Court also said it was going to come to exactly the same outcome if it went down the EU law route. The Supreme Court also found that charging higher fees for Type B claims was indirectly discriminatory because it was not consistent with the aims of the fees order overall. It wasn't a proportionate means of achieving the relevant aim. Higher fees for Type B claims were not necessarily more effective in transferring the cost of the tribunal service from taxpayers to users. Well, the evidence is currently unclear as to whether there's going to be a significant increase in employment tribunal claims. There is anecdotal evidence that indicates there has been an increase. However, I've also read this has been confidently explained away as multiple cases which used to be lodged on a single claim form now are all being lodged separately, rather than being caught out by that recent case which prohibited multiple cases from being joined on a single claim form where there's insufficient commonality of facts and claims. I think this point is going to become fairly apparent fairly quickly because the stats will start to be produced very shortly. I would personally be very surprised if there's not a significant uptake, but I doubt very much we're going to go back to the sort of levels we saw before the fees regime was introduced. Secondly, of course, we now have the refund scheme, which has been put in place by the government for those who were unlawfully required to pay tribunal fees and EAT fees. Both claimants and employers who have been ordered to pay tribunal fees at Employment Tribunal or EAT stage are able to claim refunds. The gov.uk website has a section devoted to obtaining a refund for those who were ordered to pay fees between 29th July 2013 and 26th July 2017. Applications can be online, by post or email. There's a choice of statutory forms to be completed depending whether you were someone who paid the fees directly or if you were ordered to pay the fees, an employer for example ordered to pay claimant fees, or alternatively if you were paying the fees for someone else to make a claim, if for example if you were a lawyer or a trade union. But to my mind, I think it was clear all along that this case was going to be the most important case of the year. So, do you challenge me on that, Miriam?
No, I totally agree, and I think anecdotally, sort of from my own experience, cases are taking longer now to go through the system. So I think there has been an impact, but I agree certainly with ACAS conciliation having come in the interim, came in 2014. That has impacted claim numbers and will continue to do so. But the tribunal is going to have to adjust to the new volume of cases, and that's inevitably going to take some time.
Quite. So there we almost are. Thank you very much for listening. We hope you've enjoyed the Christmas podcast episodes. Miriam and I, we thoroughly enjoyed it.
Yeah, it's been fun.
And we're going to be back in the new year, as I said at the end of last episode, with New Year's resolutions, picking out an as yet undetermined number of cases to be decided in 2018, arguing about their prospective importance. It almost only remains for both of us to say thank you very much indeed for listening to the podcasts.
Thank you.
And Miriam, as a guest to the podcast, I know you're a co-presenter, but for this purpose you're about to be a guest. I always ask guests to nominate a film, book or music and tell me why it's important to them. Maybe we want to make it festive. So festive book, festive music or festive film. You can choose one. Just give us one of them and why.
One of them. Okay, so I'm sure regular listeners to your podcast, Nick, will know that you are a big fan of cheesy romantic comedies. So I'm just the same. So my festive pick of a film would be Love Actually, which I know is very cheesy, but I always enjoy watching it with my family. It feels like Christmas is coming.
So. Is it a regular Christmas routine?
It is. So,
that's nice.
Yeah, and it makes me feel like Santa's just around the corner. So I pick Love Actually. I'm sure one of your favourites too.
I'm just not commenting on that. Thank you very much indeed for listening. We really appreciate the feedback that you get to the podcast generally during the year, so please do let us know if you have any comments or questions. We hope you all have an excellent Christmas. Very best wishes from both of us for the new year, and we'll see you in 2018.
See you next year.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening.